And as usual, we're very active in the Supreme Court this term. If we have some time, I'll mention some of the cert petitions that we're supporting and some of the cases that we're filing in. But without any further ado, I'd like to introduce our moderator. Actually, before that, I'll let you know that the program is being recorded. And if you have any questions during the program, you can put them into the Q&A function. Also, we have some of the press releases that we've put out this year. So Jay Stevens is of counsel at Kirkland & Ellis and served as chairman of Washington Legal Foundation's Legal Policy Advisory Board. He was nearly 13 years as senior vice president and general counsel and secretary at Raytheon Corporation. Jay also enjoyed a distinguished career in public service as Associate Attorney General of the United States, U.S. Attorney for the District of Columbia, and also Deputy Counsel to the President of the United States. Jay, if you can introduce our speakers and then get us started.
We're delighted to, Glenn. Thank you very much. Welcome to everyone. I'm delighted to have an opportunity to spend a little time with such a distinguished panel as we have today. And really, as well, I'm delighted to be able to participate in the WLF forum on the court. Looking forward to the next term of the court. WLF, as you know, is very active and very engaged in appellate litigation, and particularly litigation before the court, filing a number of briefs both for cert petitions as well as on merits, and has had quite an impressive record, I think, in terms of issues related to economic liberty, issues related to free speech, issues related to free enterprise, and a range of business regulatory type of litigation issues and questions, legal process questions, rule of law issues, etc. So delighted that our panel is here today to share some of their insights and wisdom and thoughts about the forthcoming term, and perhaps some reflections on the past term and what that may mean for the year ahead. Joining us today is John Elwood. John is at Arnold and Porter here in the Washington office and leads their appellate and Supreme Court practice. He's argued a number of cases, I believe perhaps 9 or 10 cases before the Supreme Court, and he's very engaged in appellate litigation. He also has been teaching at the UVA in their Supreme Court litigation clinic. He's delighted to serve and write for the SCOTUS blog, and writes a column for that. And he's also served as assistant to the Solicitor General of the United States and as senior deputy assistant attorney general in the Office of Legal Policy at the Department of Justice. 2005 to 2009, he's clerked for Justice Kennedy on the Supreme Court. Also joining us today is Shay Dvoretzky. Shay leads the Supreme Court and appellate practice at Skadden Arps in the Washington office. He represents clients in a wide range of industries and areas and has argued cases in the Supreme Court. I think he's had more than a dozen arguments there. He's argued cases in the appeals courts across the United States and in some of the state appellate courts as well. He previously clerked for Justice Scalia on the Supreme Court, and also for Judge Michael Ludig on the Fourth Circuit. Also joining us today, Anastasia Bowden. Anastasia leads the Pacific Legal Foundation's Economic Liberty Practice area, where she spends considerable focus and time on challenging competitive licensing laws and laws that are designed perhaps to restrict economic freedom and freedom of speech, challenging those provisions. In addition to litigating for the Pacific Legal Foundation, she testifies before state legislatures on issues related to occupational licensing and the impact that has on entrepreneurship. She is co-host of the Pacific Legal Foundation's Supreme Court podcast, DIST. And most importantly, early in her career, we claim that she got her fundamental grounding as a young attorney with the Washington Legal Foundation. So we're delighted that you are joining us today, and we look forward to your thoughts and comments. With the restraints and restrictions of virtual podcasting, and with the impact of how to manage and move smoothly among each of you, I do want to encourage you to I was going to say raise your hand, but engage, make your comments. Don't hesitate to interject as you can to ensure that we get your thoughts and views and try to keep this somewhat interactive as we can. I would like to get a few of your thoughts on some issues generally, and then we'll go forward on some of those general background issues to cases that are before the court this term. So, John, let's start with you briefly, if we could, please. I know you've spent a considerable amount of time looking and working with the court, thinking about the court, but perhaps it would be worthwhile reflecting on some of the things that have occurred over the last 3 months during the summer. We've seen Justice Breyer have a couple engagements, both at the Harvard Law School, I think, and elsewhere, and he's written a book regarding issues and concerns about the Supreme Court becoming just another political institution or becoming too much of a political institution. And the same, I think, for Justice Barrett, who has done a speaking engagement in Kentucky where she was expressing some concerns about the impact and efforts of some to make the Supreme Court just another political institution. And I must say it's something of concern that a number of us who are interested in and care about the court have concerns about. So, John, if you could just share some thoughts and views about how you see that initially, and then I'd like to get Anastasia and Shay's views on that as well. John?
Sure. First of all, can you hear me?
Yes.
Okay, great. I'm sorry you can't see me. Just think of somebody who's very good looking. So in addition to Justices Breyer and Barrett, Justice Thomas had a speech recently where he also kind of made the same point about how the Supreme Court is not a political institution. It's something that we periodically see them doing, see the justices doing. Partly that's in response to a lot of the drumbeat about what is going on about the so-called shadow docket over the summer. Chief Justice Roberts famously said when he was a White House lawyer that only Supreme Court justices and school children are expected to and do take the entire summer off, but they didn't take the summer off this summer. They were quite busy entering orders, which had, were quite high profile and looked, like some people were portrayed in the press as deciding things which are still actually kind of open. There are several that were very noteworthy and, they were high profile cases, which I think tell us something about what might be coming down the road. First and most narrowly, the court vacated a district court stay of its own order invalidating the CDC's eviction moratorium. That's a lot to follow, but basically they said that they allowed an order invalidating the CDC's eviction moratorium to go into force. The Supreme Court did. And they basically said that the eviction moratorium is toast, which I think is a pretty good indication. When the court gives injunctive relief on the shadow docket, the so-called shadow docket, on the emergency docket or as a stay docket, that's a pretty good indication of how it feels on the merits. I think that this is probably not anything that's driving the comments about the politicization of the court. But the court also granted a stay of a mandate in a case involving the state of Oklahoma and whether the eastern half of it is Indian country. Just a year ago, the Supreme Court held by a 5-4 vote that the eastern half of Oklahoma is Indian country, and the fact that they're entering a stay suggests that the court may be reconsidering that. because, of course, during the intervening time, they've replaced Justice Ginsburg, who was in the 5-4 majority there, has been replaced by Amy Coney Barrett. I think this is also not anything that is probably driving the politicization claims, but there's certainly been a lot of interest in sort of the free exercise clause and religion. And the court, in the tail end of the summer, stayed the execution of John Henry Ramirez. He wants to have not only his pastor present in the death chamber when he's put to death, he's on Texas's death row, but also wants the pastor to lay hands on him. I think that that's kind of significant just because in recent years, the court has been very interested in sort of free exercise. But here is something that I think is driving the politicization claims that the court handled over the summer, which is that the Supreme Court basically declined to enjoin a Texas statute that provides for private enforcement of an abortion ban, a heartbeat bill, and the court, by a kind of a narrow vote, I think it was by 5-4 vote, they would not stay that, and they allowed that to go into force. And of course, that occasioned all sorts of commentary, and I think that was kind of a piece with the sort of criticism that prompted the various people on the court, Justice Breyer, Justice Barrett, Justice Thomas, to say that the court is not a political institution. But certainly, it's been a kind of an indication of what might be coming down the pike with the things that the court did over the summer. And whenever the court is saying that it's not a political institution, that's a pretty good indication that there are a large number of people who think it is. And one thing, a recent headline that was kind of interesting to me is that the court has record disapproval. There's 37% approve of the Supreme Court, 50% disapprove, which is almost a flip of where it was last year at this time, which was 52% approval, 37% disapproval.
So, Anastasia, do you have some thoughts and comments about how you see this issue, and particularly Justice Breyer's book and how he is reflecting on this? And then we want to talk a little bit about what that might mean for the court if those who are seeking some decision from Justice Breyer.
Yeah, I have been following these comments, as you said, not just Justice Breyer, but also Justices Barrett and Justice Thomas recently. And I do think this is an appropriate thing to do. And in fact, it's probably an imperative thing right now and part of public education, because there's so much that the public gets wrong about the Supreme Court. And it's nice to have a sort of united front comprised of justices with different judicial philosophies saying exactly that. These are judicial philosophies. This is not partisan politics. The court is not broken. And you're going to do long-term damage to it if you do something like court packing, which politicizes the court and tarnishes the way it's viewed. Not to plug my own podcast here, but I can't resist an opportunity. Next season, we're doing an episode on the dissent in West Coast Hotel versus Parrish. And this is the case where there was the supposed switch in time that saved 9. And everyone thinks, that's what we are taught, that Justice Owen Roberts' vote in that case was due to court packing. And we now know in hindsight that after the justices' papers were revealed, that Justice Owen Roberts cast his vote prior to court packing even being introduced. But when you bring up the idea of court packing, it just politicizes the entire endeavor, and people chalk anything that happens post that event to court packing and to politics, even though we now know, like I said, that wasn't what happened in West Coast Hotel. And so I think it's a good thing that the justices are making these comments, and it's not surprising given that the Biden Commission on the judiciary is set to release its report next month. The justices are out there making some comments about it. The question is whether it's effective, given that these speeches are often misquoted in the media and used and abused for people's own purposes. But I think the comments themselves have been really heartening and very appropriate.
Shay, you spent some time, in fact, you've written an article, I think, for Reuters publication, reflecting on the past term and drawing some conclusions about consensus and alignment of the various justices on the court. And I think maybe with a conclusion that, it isn't all as divisive as we might think it is, but I'd be sort of interested if you could share some of your thoughts and some of your conclusions and perhaps some of the views that you developed in that article with our audience today, because it's a pretty interesting reflection on the prior term.
Sure. Thanks, Jay. I do think that last term there was more unanimity and the justices managed to achieve narrow consensus, I think more often than people were expecting, given some of the potentially high-profile cases that were on the docket. So if you look at cases like California versus Texas, the court by 7-2 upheld the Affordable Care Act for the third time. Fulton versus City of Philadelphia, everybody was watching that case as a possible vehicle for overruling Employment Division versus Smith. The Supreme Court unanimously didn't do that. In Mahanoy Area School District versus BL, the court issued a narrow ruling about schools' ability to regulate off-campus speech by students. Each of these cases was expected to be a potential blockbuster, and either unanimously or by a wide margin ended up adopting a pretty narrow holding. There were also some unexpected alignments on the court. Van Buren versus United States is one that I find interesting because that was a ruling by the 3 more liberal members of the court, joined by the 3 younger conservative members on the court. So an opinion written by Justice Barrett and joined by Justices Gorsuch and Kavanaugh, along with the 3 more liberal members of the court. That may perhaps foreshadow a generational divide among the conservative justices on certain criminal law issues. Transunion versus Ramirez was another one where I found the voting lineup to be interesting. That was a 5-4 decision about Article 3 standing, with Justice Kavanaugh writing the opinion of the court and Justice Thomas joining the more liberal justices on the court in dissent. So that said, though, there was still a lot of disagreement. Some of it was on the shadow docket, on COVID restrictions, as John mentioned earlier, more recently on the eviction moratorium case. Some of the disagreement manifested itself in separate writings, even in some of the decisions that I just talked about as being unanimous for the court. So for example, in the Fulton case, that was the one about Employment Division versus Smith, Justice Alito wrote a 77-page concurrence criticizing the court for not going far enough. The other interesting thing I think about some of the separate writings, some of the language in the separate writings was quite caustic, which is unusual for the Supreme Court justices talking to one another through their opinions, including even by the Chief Justice, who I think during his tenure on the court has really made it a goal to promote civility and to try to find this kind of narrow agreement that the court showed last term. So in one concurrence, for example, in the Lang case, he denounced the majority's approach as absurd and dangerous. In another opinion, another case where he dissented by himself for the first time in his tenure on the court, he criticized the majority for turning judges into advice columnists. This is relatively unusual language for the Supreme Court. And so I think the question heading into the next term is those disagreements are very much real. They're very much there despite the court's ability to find unanimity last term. Will those disagreements bubble over this term into potentially watershed holdings in cases about abortion, guns, religion, the death penalty, and so forth? Or will the court again be able to find narrow consensus? And if those cases do end up being deeply fractured, what does that potentially mean for the business docket? You can imagine that if the court issues a number of 5-4 or 6-3 decisions in these hot button areas, maybe they would use some of the sleepier cases on the business docket in order to try to find consensus. But those cases too can be quite controversial. I think we'll talk a little bit later in this program about City of Austin versus Reagan National Advertising. That case builds off of Reed versus Town of Gilbert from a few years ago, which generated confusion in the lower courts as a result of several different separate writings. The American Hospital Association case about administrative law is a business case, but raises some fundamental questions about administrative law potentially. And so looking forward to the next term, it'll be interesting to see how these patterns play out and whether the court is able to again forge consensus, or whether some of these very real disagreements from the last term spill over into more fractured holdings.
Just perhaps a question to each of you is what you described, Shay, a edginess to judicial philosophy, or does it reflect a little more personal edginess among the justices? And maybe more importantly, what does that mean for an advocate before the court in terms of how you shape your advocacy and your briefs? Does it affect how the justices are deciding cases and therefore how you are arguing cases?
So I do think that it affects how you argue cases, because it's almost like you're arguing to two different audiences. You still need to make arguments based on first principles, and sometimes arguments based on first principles can lead to sweeping positions. And those are the ones that last term tended to feed the separate writings rather than the majority opinions. At the same time, knowing that the court is looking for consensus in so many cases, you also have to find a way to offer the court that narrow ground to reach a decision. And so looking at the briefing and the argument in the case as a whole, and by that I mean both your own brief and your amicus strategy, you need to find a way to cover both grounds and give the justices that kind of a menu of options to choose from, I think.
Anastasia, you have some thoughts about this issue and how it might affect how you posture arguments and cases before the court?
Yeah, I think Shay is exactly right that you do see advocates trying to craft narrow arguments to get consensus when necessary. But at the same time, and particularly, at Pacific Legal Foundation, where we are arguing from first principles and very committed to individual rights, sometimes you can't make those concessions. And so, I was thinking about this. There were a lot of narrow cases last year, and yet Pacific Legal Foundation won a sweeping and complete win for property rights in our Cedar Point case, which was really surprising for that term. And so we were prepared we had other alternate arguments that could have been a little bit more narrow, but we did swing big. And I think ultimately it'll just come down to whether you can garner the votes or not, but it's wise always to do both things.
John, you have any thoughts or comments about this issue that you want to share?
Well, just as a kind of a historical thing, I think it's exactly right that you have to both have arguments that will appeal to everybody, and you do try to have a consensus argument and be prepared for when particular justices have a more idiosyncratic take. You have to be prepared for that, preferably one that doesn't lose you other votes, and that you do have you can have to right size it. It's great when you can swing for the fences and actually get your win, but you have to be prepared for that fallback position if they're clearly not buying that. But one thing I will say is that as an advocate, it's become in some ways easier because the spread may be different, or maybe the justices are just different, because one of the things I used to especially dread was when you would spend 5 minutes of a fairly short argument, a 30-minute argument, with Justice Scalia trying to get you over to one particular position that you knew would immediately alienate Justice Kennedy. And that was always kind of a tough thing to have to triangulate. And there are definitely kind of differing views on the court, but I find them a lot easier to work with during oral argument now.
It may not be a fair question, so don't feel obligated to answer, but do you have any prognosis that you might offer regarding the continued tenure of Justice Breyer on the court, and whether those kinds of issues are going to be driving the tenor and tone of things going forward over this term?
I think it's impossible to predict. It's just absolutely impossible to predict because, I I had a hard enough time predicting when my own boss, Justice Kennedy, was going to retire. He retired a year after I thought he would. And but my current thinking, which is worth what you paid for it, is that he's actually going to retire at the end of next term. But after having made a big display of not retiring now because that would be too political, he will still retire in time to be replaced by a Democrat with a Democratic Senate. But you know, who knows? Justice Breyer is famously idiosyncratic. And I think we'll see that on display in this, as we've seen in every other aspect of his career.
I think one of you, it might have been you, Shay, in your article, indicated that one of the significant issues that might be impacted, which obviously doesn't drive as close to the interests and concerns of WLF, but is that Justice Breyer's approach to criminal justice issues, and that he generally has been a little more focused and a little more supportive of the government's position in terms of criminal justice issues than a replacement might be.
I think that's right. I think if you look at his tenure on the court, the characterization of his record that you just articulated is correct. And I think if you look at some of the judges so far who have been appointed to the lower courts by the Biden administration, you see a lot more public defenders and people with that sort of background, certainly than you did under President Trump, but also more than you saw under President Obama or under President Clinton. And so looking ahead, you might think that whenever Justice Breyer is replaced on the Supreme Court, his replacement will be more pro-defense than he is. At the same time, as I mentioned earlier, on certain criminal issues, the younger conservative justices are perhaps less law and order focused than Justice Scalia, for whom I clerked. And so that'll be an interesting shift to watch over the years on the court.
Well, why don't we may come back to this issue, but let's spend a little focus and time on some of the cases that are before the court this term. Some of you are involved with those cases. I know all of you are familiar with generally some of the key issues, at least in the business regulatory area. So let's focus for a moment on CVS v. Doe. Shay, you want to sort of take a crack at that and sort of lay out the fundamental issues and what's really sort of at the fulcrum there of the decision points for the court?
Sure. So the basic issue in this case is whether the Affordable Care Act creates a cause of action for disparate impact liability that can be pursued by plaintiffs who are alleging disability discrimination. So the plaintiffs in this particular case are 5 individuals living with HIV. They sued on behalf of a class, and they sued CVS. They rely on prescriptions that they get through their employer-sponsored healthcare plans. And under those healthcare plans, they have to get those prescriptions directly from CVS, either in person at a CVS pharmacy or through mail order. They argue that kind of an arrangement has a disparate impact on their ability to access the medications that they need, and that there's liability for that under the Affordable Care Act. CVS sought cert, and there was a 4-to-1 circuit split on this issue, with only the 6th Circuit holding that such disparate impact claims are not permitted under the Affordable Care Act. And CVS argues that this is a pretty simple statutory case. The statute prohibits discrimination, quote, solely by reason of somebody's disability. It doesn't have the sort of magic language that the court has typically identified as the basis for disparate impact liability. It doesn't say something like if a practice otherwise adversely affects a particular group. And so CVS argues on that basis that there is no disparate impact liability under this statute. I think this case is important for a couple of reasons. One is the effect on healthcare plans themselves. The kind of healthcare plan that I described is very common for prescription benefits. It's also the essence of an HMO plan for seeing doctors. And if you can have disparate impact liability on the basis of such a plan, that's potentially unsettling to the healthcare system, to healthcare providers, to employers, and so forth. I think the other reason that the business community is concerned about this case is that typically when Congress clearly creates disparate impact liability, it also incorporates certain statutory defenses to disparate impact liability. So if you look, for example, at disparate impact liability under the Americans with Disabilities Act, there is a defense there if the particular practice is job related and consistent with business necessity. And a defendant doesn't need to accommodate if that would impose an undue burden. These are express statutory defenses. If courts recognize a disparate impact claim under the Affordable Care Act, the statute doesn't include any of those defenses. And so businesses are potentially subject to liability under a pretty freewheeling, judicially created form of disparate impact liability, which can just generally lead to a lot of uncertainty and expense for businesses. So I think that those are some points about the significance of this case.
Sort of staying with healthcare for a moment, there's another healthcare case before the court, Cummings v. Premier Rehab Keller, related to the Rehab Act and the Affordable Care Act. What are your thoughts about that, Shay, and what are the sort of the key issues there that we should keep our eye on?
So the key issue in this case is whether damages for emotional distress are available for violations of the civil rights statutes applicable to recipients of federal funds. So these are the spending clause statutes. The case came to the court on only a 1-to-1 circuit split, and the court called for the views of the Solicitor General on this issue. The Solicitor General recommended a grant and also sided with the plaintiffs, urging the court to hold that emotional distress damages are available. The issue is important because in cases of disability discrimination, oftentimes emotional distress damages are the only ones that are at issue. And so if you look, for example, at the facts of the two cases involved in the circuit split, in the case before the Supreme Court, you have a plaintiff who is deaf and legally blind, and she claims emotional distress when the defendant refused to provide her with a sign language interpreter when she sought treatment for chronic back pain. In the other case involved in the circuit split, I think coming out of the 11th Circuit, an MRI facility refused to allow a blind mother with a child or with a guide dog to accompany her child during an appointment. And so the only damages that you're going to see in cases like that are emotional distress damages. And I think that's why the administration, particularly this administration, weighed in on the side of the plaintiffs in urging the court to recognize that kind of relief.
Is this primarily a statutory interpretation question, or how do you see the issues then?
It's statutory interpretation, but it also has to do with the background principles of law that Congress was legislating against when it passed these statutes. So the Fifth Circuit in this case held that emotional distress damages were not available on the ground that those sorts of damages are not traditionally available for breach of contract claims. And the spending clause statutes are in essence contracts with recipients of federal funds. The plaintiff here and the United States in support argue that actually no, emotional distress damages have long been available where you have breach of contract claims that are about something other than pecuniary interests. In those sorts of situations, you can receive emotional distress damages. And so I think it's statutory interpretation, but there's also a heavy component here of what the background legal principles are that Congress was legislating against and how those get incorporated into the statute.
If the court were to go with the Justice Department administration's view, would that portend for a much more expanded view of contract damages in other areas potentially down the line, or is this really sort of focused on healthcare type of claims and concerns?
I think methodologically, you're right that it could open the door to these sorts of broader questions. For what it's worth, I think that if this court does side with the plaintiffs and with the government, it will probably look for a narrow way to do it so that it's not making some broad sweeping methodological pronouncement. But you're right that there is the potential for that.
John, another case that's before the court, American Hospital Association v. Becerra. I think that case has some implication for the deference that may be related to the Chevron case. You want to share some ideas and thoughts about that case and how you see it, and what the sort of the pivot points are in the arguments before the court in that case?
Sure. So this is a group of justices who are relative Chevron skeptics. And so anytime a case raises the issue of Chevron deference, you have to confront whether the court might take the opportunity to overrule Chevron. And my short answer is that I don't think so, but I think that there's an opportunity for the court to carve away at Chevron further, which it has been doing for years, and further marginalize its impact. Now, first, some background. This involves a pretty technical statute. Under federal law, the reimbursement rate that Medicare pays hospitals for outpatient drugs is based on one of two alternative methodologies. For anyone who's still awake, the first one is based on hospitals' actual acquisition cost. The second one is based on average sales price for the drug to all buyers, not just to hospitals, but to all buyers, which HHS has some capacity to adjust as necessary for purposes of the statute. Now, HHS concedes that it doesn't have the data it takes for the first method, so it has to use the average price for the drug, which is defined by statute as 106% of what the actual average sales price is to all purchasers. So 106%, actually above the average sales price. But because the hospitals at issue were actually able to get the drugs at a discount, the government has used, the HHS has used what purports to be its ability to adjust those figures as necessary for purposes of the statute to adjust it down to 77% of average sales price. So that's quite a haircut, 31% or whatever that is. If I were good at math, I wouldn't be a lawyer. By a 2-to-1 vote, the DC Circuit said that's just fine. That was within the agency's ability, that it was ambiguous, and that was a reasonable construction of the statute. Srinivasan and Millett were the majority. Judge Nina Pillard was in the dissent, saying basically what the hospitals are arguing here, which is that if HHS wants to set rates based on what the cost is actually to the hospitals, they have to go to the trouble of getting the data to proceed under the first method. They can't just take the default method and then adjust it so they can approximate the first method. Otherwise, what is the point of Congress writing that first method into the statute? There's a separate jurisdictional question because the Social Security Act is just chock-a-block full of restrictions on jurisdictional review. And I'm candidly kind of surprised that nobody filed an amicus brief on that, because there was a lot of amicus action. So there's a question here of whether HHS should get Chevron deference in its construction of this rate setting statute. And that raises, several different courses the court could take. They could overrule Chevron, which several amici suggest they should. They should give it a haircut the way that the court gave to our deference. That is the deference you give to an agency's construction of its own regulations, which it did a couple of terms ago in Kaiser. And they really, really dialed it back by kind of a fractured vote. Or you do something else with it. And I think what they're probably going to do is fall into this something else course, but I think that they're probably going to give Chevron a very narrow construction. I will note, by the way, that the amici who say give it a Kaiser-style haircut include some very prominent practitioners. Paul Clement, former Solicitor General, Evan Young, Baker Botts Austin, and the New Civil Liberties Alliance have all argued for a Kaiser-style haircut. I think it's unlikely the court either overrules Chevron in this case or gives it a Kaiser-style haircut, for the reason that the petitioner hasn't argued for it, and the court typically won't address arguments raised only by amici, although sometimes they have. I don't think they have since Teague versus Lane, although I'm sure there's an intervening case. And also, there hasn't been briefing specifically on that. And this has generally been kind of a lowercase c conservative court in that they generally go slow on these things. It took the Supreme Court 3 tries to overrule Elwood versus Detroit Board of Education about compelling non-union employees to fund political or ideological activities of unions. And if it took them 3 tries to do that, they're not going to do this on the first try. They also missed the opportunity to overrule Employment Division versus Smith and Fulton last term. So, basically, if their hand isn't forced, they generally aren't going to do that. But I do think that it's very likely that the court will read Chevron narrowly. Judge Kavanaugh, or Justice Kavanaugh in Kaiser, wrote that courts will almost always reach a conclusion about the best interpretation of the regulation at issue if they use all tools available for eliminating ambiguity. There's a footnote in Chevron that says, before a statute is ambiguous, you have to use all the tools in the toolbox to decide what its best meaning is. And Justice Kavanaugh, who was in the majority 97% of the time last term, said that's almost always going to resolve it. You won't have to go to, you won't have to defer to the agency. And if that's what they do, is double down on that and really fly-spec the statute and say that answers the question, we don't even have to get to Chevron step 2, that will be a further kind of marginalization of Chevron, I thought. As an aside, I thought that Kaiser spelled the end for efforts to overrule Chevron, because what we had that term was instead of overruling Auer, the court defined it very narrowly by a splintered vote for justice plurality, which the Chief Justice joined only for precedential reasons. He said he wasn't going to overrule it. And I was very struck there that some of the reasons for overruling Auer deference were the same reasons that are voiced for overruling Chevron. And I thought, if you can't overrule Auer, which is more recent and more flimsy, what are your chances of overruling Chevron, which is far, hoarier and far more established in the law? But of course, something important happened since then, which is we lost Justice Ginsburg and replaced her with Justice Barrett. And so it could be that they don't even need Chief Justice Roberts' vote in order to eventually overrule it. I don't think that's going to happen this time, but I wouldn't be surprised if we get further shots across the bow from the biggest Chevron skeptics on the court, such as Justice Gorsuch.
I hesitate to venture this comment, but after listening to your erudite discussion of that case and the prior discussions on the 2 healthcare cases, one would think that if the public were exposed to the general explanation about how courts decide cases and what the issues are in the vast majority of cases, and realize that perhaps it's a difference of judicial philosophy that drives these decisions, I think they might come to the conclusion more quickly that this really isn't a partisan decision-making process, but that it is it's a judicial philosophy impact kind of process, because I think the concern is that those cases, which are such hot button cases that seem to drive such a partisan public view of the court, really ends up distorting what may be transpiring in 90% of the other cases, and we really end up trying to overcome some public perceptions that are frankly destructive of the court, when in fact the court is functioning really quite exceptionally well. And as Shay pointed out in his comments in his article, we really see a court that drives in many ways to try to get to a consensus point of view, and is not deliberately seeking to just count votes and on a partisan basis to see which side might prefer the outcome and which outcome they might prefer. But anyhow, let's move on a little bit. Anastasia, you're particularly engaged with some of the First Amendment cases. So perhaps you could spend a little time walking us through City of Austin to start with. And there may be another case or two that you've been engaged with on First Amendment. A critical issue. It seems to be a critical issue across the board, whether it's speech or whether it's freedom of religion, et cetera. And it's one which has become a pretty central focus in many ways in our culture and society in the last 10 years in particular, but it's always been the core of our democracy in many ways. So I'd be interested in your thoughts about the City of Austin and sort of how you see the issues there developing and how you see the court approaching those issues.
Yeah, these issues are coming up more and more, and they are incredibly important. And it's interesting because even for me, I'm a free speech absolutist, but some of these cases are not easy, even from my perspective, particularly the second case that we'll talk about. But we'll start with this, the first case, City of Austin versus Reagan National Advertising. This is a follow-up case It's coming down after Reed versus Town of Gilbert. And this is where the Supreme Court clarified the test for whether a law that restricts speech is content-based and therefore subject to a higher level of judicial scrutiny. So prior to Reed, there had been some precedent saying that the intent of the government was relevant. And so long as there was no intent to censor the speech based on its content, so long as the government could justify its restriction with reference to some other purpose other than censorship, the court would not consider the law content-based and subject to a higher level of scrutiny. And in Reed, the court said, no. Whether a law is content-based depends on the face of the law. And so it purported to sort of clarify this test, and yet there are still some lasting questions, including whether Reed applies to commercial speech, and even then, what looking at the face of the law means. So what happened in this case, City of Austin, is that the case broadly involves the Federal Highway Beautification Act, which requires the regulation of signs and billboards adjacent to interstate highways in order to get federal funding. Pursuant to that act, the City of Austin, Texas has various highway sign regulations, which it says protect the health, safety, and general welfare of the city and its residents. And this paternalism always makes me a little bit crazy, where these cities are saying we have to protect people from ugly signs. But in any event, what those regulations do is they disallow off-premises signs. That is, signs that advertise something off-site. So if there's a pizza parlor nearby, you can advertise for the pizza joint, but you couldn't advertise for, say, Pacific Legal Foundation because we're located all the way over here in Sacramento and we're not nearby that billboard. So on-site signs, and a few others are allowed. Off-site signs are not. But the existing signs that existed when these regulations were passed were grandfathered in, so long as they don't change their technology or increase how much they don't comport with the new statute. And so a group applied for a permit for an off-premises sign that had been grandfathered in because they wanted to change the technology and make them digitized. Of course, digitized signs are the new thing, right? And they were rejected, and they challenged Austin's sign regulations. And the trial court said that these regulations, which distinguish quite obviously between on-site and off-site signs, are content neutral and permissible under intermediate scrutiny. The Court of Appeals reversed and said because one has to read the sign to determine whether the law applies to it, the law discriminates based on the content of the sign and it's subject to strict scrutiny, which it could not meet. So the government petitioned for cert and the Supreme Court granted review. And the question is, how do you determine whether something is content-based? The government says it cannot be whether you have to read the sign to determine whether the law applies. I found some of the city's arguments kind of amusing. It says, well, we're not censoring these signs based on their content, but simply to organize them. And that's the very argument Reed rejects. It doesn't matter what your purpose is, it matters what you're doing. And here they're distinguishing between different types of signs depending on what they say. The city also says that under its ordinance, the critical feature of whether it's subject or whether it can be placed on a billboard or not is not its content, but its location. So it says an Eat at Joe's sign is permissible depending on where it is. So this isn't content-based, it's location-based. And the sign companies say you're missing the point. Some signs are allowed at this location and not others, depending on their content. And so it's kind of interesting to see these sort of lawyer games that people play in order to get them to fit into the box of content-based laws. I think this is a problem that naturally arises when you have tiers of scrutiny. I encounter this all the time in my practice because I very often challenge laws that are subject to what's called rational basis scrutiny, which is the lowest level of scrutiny available. And lawyers will play all sorts of games to pretend that there are restrictions on speech or what have you to get them into a higher level of scrutiny. And so I think this game is sort of endemic to tiers of scrutiny. But here the court is going to have a chance to try to clarify at least how you get into that box of strict scrutiny.
But perhaps you could just share briefly the levels of scrutiny that are applied in First Amendment cases and sort of the rationale for those different levels that the court.
Yeah, absolutely. Yeah, so there is strict scrutiny, which is a very high burden. There are people who have said that strict scrutiny is strict in theory, fatal in fact, because it is such a high burden for the government to meet. And that's what applies to content-based laws, as we've been discussing. But there's also intermediate scrutiny for content-neutral laws, which simply requires that a law be substantially related to an important state interest. That's compared to strict scrutiny, which requires that a law be narrowly tailored to a compelling state interest. And, the justification is that different laws implicate different interests, and that there's a reason to be really skeptical in some cases and a reason not to be skeptical in others. I think that gets it a little bit wrong because the government can be very good at playing subterfuge, that it can pass a law and give you all the good excuses in the world. I mean, all I do is sue the government, so I'm very familiar with this, is that they'll pull out every justification in the book and tell you that it's not something pernicious. And I think that we need one level of scrutiny to protect our rights very vigorously. And frankly, if it's applied consistently, it shouldn't be a problem when for the government. If the law has a really good justification, it's going to meet any level of scrutiny. And if it has a bad justification, then it really shouldn't matter. So to my mind, we only need one level of scrutiny, but that's not the world that we live in.
Perhaps you could take a little time on a second First Amendment case, which raises what appears to be really the interesting situation where elected bodies are seeking to censure individuals in their own body for comments and speech of the members, which I would think raises concerns across the spectrum for those who are concerned about free speech and suppression of free speech.
Yeah, I think this case is really interesting. This is another petition out of the Fifth Circuit, and it involves whether an elected body, as you say, can constitutionally censure the speech of one of its members. So we've got a whole coalition of states on all sides of the political spectrum involved in this case because they're concerned about their ability to censure its members. And so the case, Houston Community College System versus Wilson, involves Mr. Wilson, who was elected to the Houston Community College's board. And as the board says in their petition, chaos ensued. He spoke out against the community college system's anti-discrimination policy. He opposed setting up an overseas campus. There was a bunch of media controversy surrounding this. He filed lawsuits against the college. And in fact, those lawsuits threatened the college's accreditation. And so what ended up happening was that the college system ended up censuring Mr. Wilson, just simply saying, we disapprove. We do not support what he's doing, and we don't think what he's doing is right. And Mr. Wilson sues. He says that violates his First Amendment right to speak freely. The district court disagreed. It said this was just a statement of disapproval. It doesn't injure his speech or injure his First Amendment rights. But the Fifth Circuit reversed. And I think it's an interesting case because you have a clash of speech interests. You have, on the one side, Mr. Wilson saying, hey, I should be able to speak freely. But on the other side, you have these legislative bodies who say, this is just our speech too. We want to be able to speak freely, and being able to criticize our members is vitally important for our ability to keep our members in line. I thought it was also interesting because I don't know what you might think about how this case came out at the Fifth Circuit, but the Fifth Circuit ended up denying the petition for a hearing en banc. And Judge Jones filed a dissent joined by Judge Willett, Judge Ho, Judge Duncan, and Judge Oldham. And in fact, Judge Ho also wrote a separate opinion saying the First Amendment guarantees freedom of speech, not freedom from speech. And I kind of love that turn of phrase. And it's such an important, interesting issue that's coming up all the time, where on the one hand, people are feeling very threatened by other people's speech criticizing them. But on the other hand, that's just the speech of that person. Why do they have to censor themselves in order for you to have full enjoyment of your First Amendment rights? I think reading the briefs is really interesting. As always, it's a great lesson in the art of lawyering because each is casting aspersions on the other. The school says Wilson is erratic and kind of conspiratorial. And meanwhile, Wilson says the school is, full of abuse and subject to lawsuits and sort of corrupt. So I always think that's fascinating to read the two briefs, which incidentally were written by two competing Supreme Court clinics. We had Stanford on the one hand and Yale on the other. So I commend the briefs to everyone.
Anything else on the free speech front at this point, Anastasia? Is there anything in these cases that ties into the ability of a chamber to set its rules and regulations for voting and speech, et cetera? I mean, so one of the things you see coming out of the House of Representatives in COVID, and whether you can vote by proxy, et cetera, whether or not, or is that not linked at all to a speech issue?
I think this case is pretty narrow. Both sides were really careful to say that the only thing going on here is speech. There's no sort of, at least on the school side, they're only engaging in speech. There's no other sort of formal punishment. It's a really narrow issue. And in fact, on Wilson's side, he said that it's so narrow as to say that this has nothing to do with the internal legislative process or speech done within the legislative process. This was completely private speech, purely political private speech outside of the legislative process. So perhaps getting back to what we were talking about earlier, the parties have gone really far to narrow the issue and to say that it should not be far reaching. So I don't know that it will have any implication to the things that you bring up.
John, well, just a reflection on something that Shay indicated in the piece he wrote. The number of cases taken by the court this past year was the smallest for the last 100 years or more, or something like that. It's quite a remarkable constrained docket. So if I understand correctly, the court is meeting next week for its long conference to consider whether or not it will accept other cases for argument in this term. Do you have any prognosis, any insights you may want to share about what cases you think have a likely opportunity to be taken on the court's docket, and what cases that perhaps are of particular interest to the business community that might be of a potential decision for the court?
Sure. There's one case in particular that I think has a pretty good chance of being granted, or at least it's going to get the court's attention. And it's cheating a little bit because it's a business case, but it also is of interest because of free exercise and free expression, and that's Dignity Health versus Minton. This is the only case I'm aware of that the court. Can you hear me, by the way?
Yes.
I'm getting some distortion. Okay. It's the only case I'm aware of that was rescheduled and relisted over the summer by the Supreme Court. They considered it at their last conference in June, and rather than act on it, they held it until the long conference at the end of September. It's the only case I'm aware of where they did that. And it involves Dignity Health, which is a corporation that runs hospitals, and this particular hospital is a Catholic hospital. And a would-be patient sued them for declining to perform an elective sterilization that was contrary to Catholic, ethical, and religious directives. And the hospital invoked the free exercise clause, but also the free expression and free association rights protected by the First Amendment to try to get around Employment Division versus Smith. And it'll be very interesting. That's another opportunity for the court to possibly overrule Employment Division versus Smith. And I think the court is hearing it, or the court rescheduled it for the long conference so it could consider it along with a case involving the Catholic Diocese of Albany, which is likewise imposes some restrictions on religious organizations. Something that is of broader interest to the business community, but perhaps not as hot button, is a case called Viking River Cruises versus Moriana, which is actually going to be considered at the October 15th conference. And it involves the California's, or, basically California's broader hostility to arbitration, because, California courts, they will follow the general idea that an arbitration agreement generally doesn't allow for class arbitration claims if the agreement is silent. But they refuse to do that. That is, that they will essentially allow the class type claims to proceed if the agreement, if the plaintiff asserts so-called representative claims under the California Private Attorneys General Act, which, like class actions, allows aggrieved employees to seek monetary awards on a representative basis on behalf of other employees. And I think that that's a very interesting case. I'm not sure. I think it might be splitless, but there are certain subjects that the Supreme Court cares a lot about, even if there isn't a circuit split, and arbitration is one of them. Although typically the court only acts summarily on those types of cases if it's splitless. But that is one I'm very interested in watching.
Speaking of California, I think Shay and perhaps Anastasia, each of you has a case that is of interest to you. Certainly, they're both, I think, fascinating cases. The Alaska Air case, Shay, you might want to spend a few minutes on that. And Anastasia, you have some thoughts, I presume, on the property right dispute with the California Coastal Commission, which is certainly a fascinating factual case. It must raise some really fascinating legal questions as well. So, Shay, you want to focus a little bit on Alaska Air?
Sure. Alaska Airlines versus Bernstein is a case about whether California's generally applicable meal and rest break laws apply to flight attendants who are working interstate flights. So California, like many states, has a law that is generally applicable. Workers, for example, at a restaurant or a retail establishment, every 4 to 5 hours are entitled to a 15-minute break. And the question in this case is, how does that apply to flight attendants? If you have a plane that takes off from California going to New York, and let's say it's a 5.5 hour flight, do the flight attendants get a break at the 4 or 5 hour mark? And if so, what does that even look like? Because under California law, these breaks have to be completely off-duty breaks, where the employees are even free to leave the employer's premises. I don't know what that means midair. So we argued in the Ninth Circuit that this law was preempted by the Airline Deregulation Act, which preempts state laws that relate to an airline's prices, routes, or services. And this interferes with services because the airplane simply can't operate if it doesn't have a full complement of flight attendants. The Ninth Circuit's answer to this was, well, that's no problem. Just add more flight attendants, add an extra set of flight attendants who can rotate on and off during the flight. Well, that in and of itself creates an ADA preemption problem because those extra flight attendants have to sit somewhere. And so you're taking seats away from paying passengers in order to give them to extra flight attendants who are mandated by California law. And that's particularly a problem on smaller planes that serve rural communities. There just aren't seats to spare for this sort of thing. The United States supported Alaska Airlines before the Ninth Circuit. The Ninth Circuit panel didn't say anything one way or another about the United States' views, just ignored that. On rehearing, we also had an amicus brief from a number of different states. And it's pretty unusual to have states filing an amicus brief supporting preemption. States usually are not in the business of arguing that state laws are preempted by federal law. So I'm hoping that that will get the attention of the Supreme Court because I think this is an important case.
Anastasia, you want to take a couple minutes on the Coastal Commission issue in coming out of the Ninth Circuit?
Yeah, absolutely. I love this case, and I'm convinced that it'll be taken up because if it's not, there is no justice at all. So this case involves PLF clients Warren and Henny Lent, who in 2002 bought a beachfront home in Malibu, and along one of its side, the prior owners had installed a fence to block off access to essentially a cliff. They didn't want people falling down the cliff. The government calls that access beach access. It's undeveloped beach access, of course, but it's true that the government has an easement for public beach access there. They've just never developed it. And so, of course, it was not developed at the time, and to this day, it is still not developed. In any event, 5 years after the Lents purchased this property, they received a notice of violation from the California Coastal Commission saying that this gate blocking off the cliff violated the California Coastal Act because it was, one, unpermitted, and two, because it blocked the undeveloped public access way to the beach. So after they sent this notice, there was correspondence back and forth for nearly a decade until eventually it culminated in September 2016 when the commission exercised their, at the time, newly granted statutory power to charge violators with fines under the California Coastal Act. So that goes to hearing, and at the December 2016 hearing, the staff requested a penalty of $900,000, but within a proposed range of $800,000 to $1.5 million at the max. At the hearing's conclusion, the commission approved a penalty of $4.185 million against the Lents. And as one commissioner explained, they were doing so because the commission didn't want to be in the position of rewarding people that have fought with the commission over these types of violations. So the issue is they were, of course, given no notice that they were potentially on the line for $4.85 million for keeping up a fence that existed when they bought the property and which was blocking non-existent beach access, that is undeveloped beach access. Although the Lents were allowed to speak at the hearing, it's important to get down to the details of what exactly went down. They were afforded no right to subpoena witnesses or documentary evidence. They had no right of any notice to those people who would testify against them at the hearing. They had no right to demand testimony under oath, no right to confront or cross-examine witnesses, no right to exclude hearsay or speculative evidence, and no right to present rebuttal testimony or evidence, despite being slapped with a $4.1 million fine that will bankrupt them. So the questions at the Supreme Court are, can a state administrative agency consistent with the due process clause of the 14th Amendment slap someone with millions of dollars in fines using a procedure that lacks any of the usual safeguards for liberty that are traditionally afforded people who face significant deprivation of liberty or money? The second question is that $4.185 million fine in violation of the Eighth Amendment's excessive fines clause as incorporated against the states in a recent Supreme Court decision? So I think the answer is patently obvious in both cases, and I do hope that the Supreme Court will take up the case to decide the same way.
Thank you. Maybe we should move. Glenn, do you have comments on any of the other cases that matter?
You're breaking up a little bit here, Jay, but I'll just mention real briefly that if anybody enjoys the game of poker and doesn't like excessive fines, read our senior litigation counsel, John Maslin's brief in support of the cert petition Stars Interactive versus Kentucky. It involves this unbelievable law in Kentucky where the state, well, actually any person can sue to recover the losses of gamblers within the state if at some point gambling was illegal. And there was a point during which the Justice Department declared online poker illegal. So it's an $870 million judgment that was issued against Stars Interactive, and the way that they determined that amount was just really outrageous. I think it's got a decent chance to get granted just because of the factual matter. And we're also going to be filing in Monsanto versus Hardeman, which is a really important issue of gatekeeping of expert evidence, and it comes up at a time when the judiciary itself is looking at revising Rule 702 to cut back on some judges' desire to leave questions like were in the Hardeman case to the jury. So that's one we're going to be filing in, one that I think is going to garner a lot of attention. But given the interest of time, that's the only two I wanted to mention. Sorry, Jay, we didn't hear that.
I just didn't know if you'd pick up any questions that needed to address, have the panel address.
No, it doesn't look like we have any questions.
Well, maybe we'll just circle back, John, and then Anastasia, and then Shay. Any wrap-up comments about the term in front of us, and then we'll close out. John?
Well, I'll be very interested to see how it plays out. Of course, the standard wisdom or conventional wisdom was last term was a transitional term, and that there's more opportunity for sparks to fly this coming term. I think that's true. It really potentially could be a real blockbuster or one to remember. I will be interested to see how it plays out. Just in the most narrow sense, we're going back to in-person argument and kind of the open outcry, the kind of free-for-all debate style or free-for-all argument style. I feel like the sort of sequential style that they did by telephone was really not a bad substitute, and had the additional bonus of getting Justice Thomas to ask questions, which I thought was a very useful thing. He had a lot of insightful questions to ask, and I think as a advocate, you always want to know you can't answer the question you aren't asked, and so I think it's a benefit to have him argue. And I hope that he continues to ask questions even when we go back to the free-for-all format. But I think it'll be an interesting case. I just wish that they'd start granting some petitions.
Thank you. Thanks, John. Thanks for participating. Anastasia?
Yeah, I'll say on the matter of format that from my colleague who argued last term and from others that I've spoken to, I think the advocates enjoyed the former format. And of course, it was a joy seeing Justice Thomas's questions. I myself am excited to get back to the free-for-all. I found the last format a little bit jarring. Chief Justice Roberts, he ran a tight shift, and as soon as your time was over as a justice to ask questions, he just cut you off, right in the middle. And I found it all a bit jarring reading the transcripts and listening to the argument, and I missed the free for all. I think it's time to get back to normal. Here in California, there's actually a bill being proposed to make all trial court arguments telephonic in perpetuity, and I think that's a shame. There's something that's missed when you're not face to face and getting to sort of hash things out face to face and with this sort of all out format. So I'm excited to get back to it. I think we're getting back to normal a little bit at the Supreme Court, and it's going to be a big term. So it's going to be a great year.
Thank you very much, Anastasia. Shay, any wrap up comments?
Sure. Just a couple points. One, on the question of argument format, I liked having the chance to persuade each of the justices. I think one of the downsides of the free-for-all approach, it's not just that the advocates sometimes couldn't get a word in edgewise. It felt like some of the justices couldn't get a word in edgewise. And so it's nice having a format where you at least get an opportunity to hear from everybody. That said, I agree that having these 2.5-minute lightning rounds feels a bit stilted. So I don't know, perhaps they will come up with some sort of a hybrid that gives you the best of both worlds. In a case that I argued last term, it was the sequential questioning throughout the argument until the rebuttal when the chief opened it up for free-for-all. So it was a little bit of both. I expect they're just going to go back to a normal free-for-all format, but I do wonder whether they will come up with some way to capture some of the benefits of what we've learned in the last 18 months. In terms of the docket, I'll echo John's thoughts that I hope they grant more cases. One thing to watch there, at the beginning, John mentioned the recent death penalty case where the court granted a stay. Unlike some of the other shadow docket rulings, the court didn't express any view on the merits there in any opinions. Rather, it set the case for expedited briefing and argument. Some people have started to refer to that as the rocket docket, as a contrast to the shadow docket. It'll be interesting to see if they do more of that, perhaps in response to some of the criticism of the shadow docket. But if they do, that might have the nice benefit of adding some cases to their merits docket as well.
Thank you very much. I appreciate your engagement and contribution today. Glenn, you have any closeout comments to wrap up? We don't hear you. I think you're on mute, Glenn.
Hey, you would figure the moderator would know how to do this. The host, excuse me. Thank you again, Jay, for moderating, and for Shay and John and Anastasia taking the time to do this with us today. We hopefully be back in February in person. We always do a midterm assessment of where the court is. But in the meantime, keep an eye on our website, and we'll make sure that we get all of our releases and information out to those who are interested in having them. Thanks, everybody, for joining us today.
Thank you very much.